Since we've covered the UCC and the OID, I think it makes a little sense to go to the IRS website, and that's why I am now, and to just see what the IRS has to say with the technique I believe Don is using, right? So I just went to the IRS website and then I just did a search for UCC, right? And I came across an article which lists a lot of things. Basically, the article is labeled "The Truth About Frivolous Tax Arguments," sections I, D to E, right? And so when I do a search on this particular article for UCC, it takes me down to number 8, and it says contention, a form OID can be used as debt payment option, or the form or a purported financial instrument may be used to obtain money from the Treasury, which is essentially what it is I believe Don is doing with the federal government. I think Don is probably going to get himself deeper and deeper into trouble using these techniques. But again, I don't know much about UCC. I don't know much about secure party creditor. I've seen things floating around on the internet about it. I don't know much about it, so I'm not going to refute that. I'm not going to challenge the people who are using it, and I'm not going to say that it's a legitimate strategy. I'm just taking a whole step back from this thing, and I'm just going to read verbatim what is on the IRS website. And it basically says, advocates of this contention encourage individuals to use Form 1099 OID, original issue discount, or a bogus financial instrument such as a bonded promissory note as what purports to be a debt payment method for credit cards or mortgage debt. This scheme has evolved somewhat from an earlier frivolous position under which a secret bank account, sometimes referred to as a straw man account, was purportedly created at the Treasury Department for each U.S. citizen that individual could use to pay tax, non-tax debt, and claims withholding credit. Those who put forth this theory often argue that the proper way to redeem or draw on an account is to use some form of made-up financial instrument. This has frequently involved what looks like a check drawn on the United States Treasury or other similar paper instruments, bonded promissory notes. One variation of this theory claims that each citizen has a private side and a public side. This theory contends that the government owns each person's public side, or straw man, by holding title to each citizen's birth certificate. By filing a UCC-1 financial statements and their birth certificates in the state that accepts such filings, followers of this theory believe they can redeem their birth certificates. Redemptionist theories view the redeemed birth certificate as an asset on which they place a value up to $2 million and asserts the U.S. Treasury Department acts as a clearinghouse for the funds. Under this theory, they can create money orders and cite drafts drawn on their Treasury direct accounts. Courts have characterized this theory as implausible, clearly nonsense, convoluted, and peculiar. Another variation of this redemption theory asserts that persons can draw on a secret strawman treasury account by sending a Form 1099 OID, original issue debt, to a creditor, and the creditor can present the form to the Treasury Department and receive full payment of debt. The proponents of this theory appear to assert that the 1099 OID permits them to access their secret treasury account for an amount equal to the face amount of the Form 1099 OID in the form of a tax refund. And then it goes on. Proponents of this theory also argue that they have sold or transferred their debt or obligation to the person to whom they issued Form 1099 OID. And this transaction is subject to sections 1271 through 1275, and that the debt or obligation is transferred with a discount of the full face amount. The issue of the Form 1099 original issue debt then treats the face amount of the 1099 OID as other income on the individual's return. The other income amount, however, is not included in a taxable income line. Persons asserting this theory often significantly overstate withholding and claim an excessive refund in amount close or identical to the inflated withholding. And then it talks about the law. The law. As the instructions to the form 1099 OID indicate, the purpose of the form is to report the original issue discount of holding of OID obligations, like certificates of deposits, time deposits, bonds, debentures, bonus savings plan, and Treasury inflation index securities, having a term of more than 1 year. OID is simply the excess of the stated redemption of the deposit, bond, or other financial obligation at maturity over its issue price. Under Section 1272, OID is taxable as interest over the life of the obligation and must be included in the holder's gross income taxable year that the obligation is held. Certain obligations are expected, including United States savings bonds and short-term less than 1 year and tax-exempt obligations. The Form 1099 OID is in no way a financial instrument. It is not a legitimate method of paying any of the public or private debt. And it is not a means to withdraw or redeem money from the Treasury. Furthermore, as the Federal Court of Appeals for Sixth Circuit stated in the United States versus Anderson, the Treasury Department does not maintain deposit accounts against which individuals can draw a check, draft, or any other financial instrument. The notion of secret accounts assigned to each citizen is purely fantasy. And then it goes on to say, in addition to a potential civil and criminal tax penalties for misuse of the Form 1099 OID, persons who fraudulently use false or fictitious instruments may be guilty of federal criminal offenses such as sections 287 and 514A of Title 18. The IRS warned taxpayers of the consequences of making such frivolous arguments in Revision Rule 20521, Revision Rule 2005-21, 2005-1, CB 822, discussing the straw man theory, and Revision Rule 2004-31, 2004-1 CB 617, discussing the commercial redemption theory. So let me just click on some of this stuff and just get the gist of it. Oh, so now we have to go. So 205-21. Frivolous tax return, use of the straw man to avoid tax. Right? So apparently this ruling emphasizes taxpayers and promoters and return preparers that a taxpayer cannot avoid income tax on the erroneous theory that the government has created a separate and distinct entity or straw man in place of the taxpayer, and that the taxpayer is not responsible for the tax obligation of the straw man. This argument has no merit and is frivolous. So there you have it. This is what's coming from the IRS, and you definitely want to be careful when you're dealing with those people, because you can be arrested, and you don't want to be sitting in jail. In my opinion, I wouldn't want to be sitting in jail over this stuff, but I do believe that I'm just going to tell you what I believe, right? And I'm not telling you to do any of this stuff. I damn sure would never tell anybody to do any of this stuff. I will say that you have natural rights, and I would say, the government has created a straw man. I think the straw man does exist, and there are certain legal rights and obligations applied to the straw man, and then there are certain rights that you have as a natural person, right? So I don't want anybody to get into any trouble. I'm just saying this, giving my own personal beliefs as to natural rights and the rights of a corporation. The straw man is basically a corporation. It's a way for you to interact in commerce, and I would never advocate that someone don't pay taxes. They will lock you up for that. There's plenty of people whom have been locked up for that. Um, so this is just kind of a crazy world that I'm almost afraid to even touch. But there you have it. I read it for you verbatim. This is the IRS's website, and they're not trying to hear a straw man argument when it comes down to that money. You best believe they're not trying to hear it. So be wary. As I do believe you have certain natural rights, but even the Constitution says that you have to pay taxes. And I already know that I'm probably going to piss a lot of people off either way. If I support the straw man, if I if I go against the straw man, I'm just going to piss people off. And I know I'm going to piss people off when I talk about taxes. So just go ahead and leave your thoughts about paying taxes down in the section in the comment below. But just be wary. Government probably is watching these videos. So you will never hear me come out and say you shouldn't pay taxes. You'll never hear me come out and say this is how you get around paying taxes. No, I give my taxes to my accountants, and my accountant uses the law to handle my taxes. That's how I deal with taxes. And furthermore, I believe that taxes are necessary to basically pay for the common needs of the government, right? So that's what I have to say about taxes. But this is what I believe Don Russell is essentially doing, and as you can see, he's going to get another charge. He is going to get himself he's going to get himself another charge, because they have already dealt with people who has tried to use these arguments, and they've made new laws for people who continue to try to use these arguments. So he's going to get a charge. He's going to get another charge. That's my opinion. He may not, but I believe he will, because they're probably going to see an opportunity to make an example out of people that are in this movement. All right. So let me just finish up. There are variations of this frivolous argument where certain individuals or groups may claim false withholding or tax payments on an income tax return or purported return using another document from the Form 1099 series, or of information returns, or a Form 2439 notice to shareholder of undisputed long-term capital gains. When such a taxpayer uses the Form 2439, the form is prepared to show false amounts of tax payments allegedly made for the taxpayer by a regulated investment company or a real estate investment trust, right? And then they actually give relevant case law, right? And you can see this stuff is recent, 2015, 2008, 2003. So, man, they're dealing with people who are using these techniques. United States v. Johnson, the Eighth Circuit upheld the defendant's criminal convictions relating to the misuse of Form 1099 original issue debt to inflate the income and claim refunds. Wow. So maybe we'll look in a separate video at United States v. Johnson. It's going to be an interesting case to look at. United States v. Heath. The circuit court convicted the defendant of presenting a fictitious financial instrument under 18 USC 514A for sending to the IRS a so-called registered bill of exchange that appeared to be a certified check, but of which there was no actual account. So look, they are actively prosecuting people who are using these techniques. Now, some may argue, hey, well, he didn't use the technique properly. Well, I mean, that being the case, you have to ask yourself, is it something you even want to try? Because if I misfill out my tax form, I don't go to jail, right? Because I'm not doing it with the intent to defraud. I just get a correction from the IRS, and they'll just say, hey, please give us X amount of information, so on and so forth. So they are going after people who are using these techniques. So if you're thinking about, and again, I don't want to piss off the secure party credit community, because to be honest with you, I really don't know what it's all about. I'm just reading what I see verbatim. But to me, it looks like this may be something you want to think about before you actually do. And it goes, United States v. Anderson, the court upheld criminal convictions relating to a conspiracy involving the creation and offering of almost 200 fictitious site draft purporting to drawn from the United States Treasury with an aggregated face value of more than 550 million, right? And then United States v. Gertsham, right? The court upheld Gertsham's conviction for conspiracy to make and pass false fictitious financial instruments in violation of 18 USC 371 514, right? Let's see what that is. Let's see what 371 is. You guys got to be careful when you go out and you start doing this stuff. So that's basically a conspiracy to defraud. I'm saying conspiracy to commit an offense or to defraud the United States. And then what's the other one? That one was 571, I believe. 571. And it is actually just definitions, right? So let's just carry on and finish this up. So United States v. Cunningham, the court held the taxpayer in contempt for refusing to comply with a court order to provide documents and testimony summoned by the IRS pursuant to an investigation regarding his participation in a Form 1099 OID scheme. United States v. Provost. The court rejected the taxpayer's issuance of an unlimited indemnity bond. Indemnity bond, keyword, that's one of the words that Don Russell used, as a frivolous and characterized his attempts to draw on government to pay his debts nonsensical and meritless. So this is exactly what Don Russell was trying to do. And he's going to get another charge, guaranteed. He's going to get another charge. And, it's going to be sad to see him kind of go down this path of not respecting the law. I'm not going to say Don Russell. I don't know what to call Don Russell, because if he thinks that he can call in bomb threats and not be held accountable for it, he's sadly mistaken. And then he's using, these techniques to try and to get himself reimbursed for money he's paid or potentially allegedly paid for the bond. Now, of course, I don't know if he actually believes any of this stuff. I don't know if he's actually done any of this stuff. Everything in this video is alleged. So when I talk about Don, I'm talking about from an allegation perspective. I'm not saying that he actually made the bomb threats. I'm not actually saying that he actually sent that letter. These are all allegations. And again, we live in a deep fake age. You can't trust your eyes. You can't trust what you see and hear on the internet. So we don't even know whether or not any of this stuff is actually coming from Don Russell. But under the theory that he is, if any of this stuff is true, then Don needs to get back on the path to reality, right? He needs to get back on the path of reality. And in our reality, the reality that most people live in, you can't call in bomb threats and think that you're not going to go to jail. You can't file original issues of debt paperwork with the government of all people, thinking that you're going to not be prosecuted for fraud, right? Now, again, I don't want to piss off the secured party creditor community. So if you guys are hearing this and you disagree with me, forgive me, but for sure, post your comments below. Break this stuff down to us, break it down, and let us understand how this stuff that is on the IRS website is wrong. Me, myself, when I refute something, I like to refute it with knowledge, and I like to refute it with information, right? So show us some case law, right? And if you can't show us any case law, show us some legitimate articles or some legitimate information on why you believe this stuff actually works. So again, I'm not, I'm not, I'm not, uh, I'm, I'm not against the secure party creditor community. I'm not attacking the secure party creditor community. This video is only really being done because of Don Russell. I actually want to understand more about secure party creditor, and I actually want to understand more about the original issue of debt. From my understanding, based what I read on this website, what I just read to you above, it's really for bonds, and it's really for sources of income that you can't claim in that 1 year. So again, so if you give me a loan, this is his example I used earlier. If you give me a loan for $100,000 and I agree to pay that money back in over a course of 50 years, and I'm going to pay you in increments of $500, well, you have to represent that interest that's going you plan to collect on your tax returns, and you can't basically say you received the money because you haven't received it. You expect to receive the money, right? So the IRS has come, this is my understanding of it, right? So the IRS has come up with this means of allowing you to claim the income, right? Because you are the original issuer of debt. You're issuing this debt to me, but the outcome of that issuance of debt is that you're going to, number one, get the original principal back, the $100,000, and you're also going to get interest on that $100,000 for me. You have to now go to the IRS and you have to say, hey, I just did a business deal with the non-lawyer. I gave him $100,000, and that's the principal, and he's agreeing to pay me. I don't even know what we haven't come up with any interest rate. So let's say the interest on that $100,000, the total amount is going to be $400,000. The non-lawyer is going to take $100,000 from me now, and then over the course of 40 years, he's going to give me back the equivalent of $400,000. How do I claim this on my tax return? Where the IRS says, hey, use this form, OID, original issue of debt, just show that you've issued debt to the non-lawyer for $100,000, and then just show that you're going to get $400,000 back in interest from the non-lawyer. That's what I believe the proper use of the form is. That's what it tells you. It says that, where is it? So it says the purpose of the form is to report the original issue discount of holders of OID obligations, like certificates of deposit, time deposits, bonds, debentures, bonus savings plans, treasury inflation index securities, having a term more than 1 year. So you're claiming the interest on the debt that you issued in that 1 year. And this is where I'm just going to stop. This is my opinion on this, what the proper use of it is. But you really should just talk to somebody. Like, if you really want to know what it is, any accountants out there, if you're an accountant, and I know there are a few accountants that watch my videos, explain to us what an OID is. Break it down to us. Educate us. But let's wrap up this video. The final case is Ernal v. Commissioner TC Memo. The court held the petitioner liable for fraud based on various filings, including phony forms 1099 OID, and imposed a penalty of $4,000 under Section 6673A. So look, and then other cases, United States v. NUP, Miller v. Commissioner. And, they're just giving you case after case for people. It's on the next page. They're giving you case after case of people who have been prosecuted and lost badly for trying to use the OID form. So to me, this is exactly what Don Russell is trying to do. I am going to go ahead and wrap this video up. Leave your comments below. Let me know if you think the secure party creditor system actually works and these people are just using it wrong. Let me know if you think the secure party creditor system is just something that's just going to get a lot of people in trouble. Let me know what your thoughts are about the secure party creditor system that you're seeing popped up over the internet. Just let me know what you think. And of course, if you're using the system and it's working for you, then, talk to us, explain to us how it's supposed to be used. But just keep in mind, anything that you post on the internet in this day and time is monitored. And there's another video that I'm going to make of how we live in a monitored state now. Everything that you post, every email that you receive, every time you step out your house, every phone call, all that stuff is monitored, right? So you got to be careful when you put information out there, when you put claims out there, so on and so forth. So that's it for this video. Again, leave your likes, questions below. Let me know what you think about secure party creditor. Let me know what you think about Don Russell's letter to the government. Do you think he is just going to get himself another charge? Do you think he is most likely going to lose the charges against the charges that are currently against him? I honestly think that Don has to get back on track with just life, because maybe losing will get him back on track, because he's allegedly done these bomb threats, and that resulted in him being locked up, and it resulted in him getting a case against him, and now he's coming out with this secured party creditor, or we'll call it, and I'll call it the original issue of debt against the government. That is more than likely going to lead to another charge. And at what point does Don readjust and say, okay, maybe this stuff is not working for me? At what point does he realize that none of this stuff is working, right? I understand what he's trying to do, right? I understand, because he's found other things in R. Kelly's case, right? I understand when you sometimes when you go to court and they have a case against you, sometimes, yes, you can get out of that by contesting personal jurisdiction. If it's a civil case and they don't have personal jurisdiction, you can contest personal jurisdiction, right? Sometimes you can go to court and you can get out of a case by challenging subject matter jurisdiction. Yes, I understand all that, but the techniques that he's using, the information that he's using, to me, it doesn't seem like it's going to work. It's not going to work. So at what point does he turn things around and say, okay, this is not working for me. I'm going to go ahead and do things a different way. And I think that's what has to happen to Don. People said that he's desperate. I don't believe he's desperate. He's caught in this mental paradigm where he believes that it's okay, allegedly, he believes that it's okay to call in a bomb threat. And he thinks that if he's brought to court for it, that court doesn't have jurisdiction over him, right? Because it's not actually a court. This is his mental paradigm. He thinks it's okay. He thinks that this 1099 original issue of debt can somehow get him reimbursed by the Treasury Department, whereas we're looking at the Treasury Department's website right now, and they're saying no, we're not sending you shit. They're saying no, we're not sending you nothing, zilch. You can't use that here. Now, again, I'm not trying to offend the secured party creditor community. I know that the community exists, and correct me if I'm wrong. You've heard the stuff that I've read. Correct me on it. Call me on it. I always invite intelligent conversation, intelligent arguments. Go ahead and correct anything that I've said, anything I've read in this video. So that's it. Please leave your questions, comments below. Please like, share, and subscribe.